Welcome to another edition, Litigation Psychology Podcast. Dr. Bill Kanaski again. This podcast is brought to you by Courtroom Sciences, courtroomsciences.com. Go to the website, everything you want for your litigation support needs, articles, podcasts, you name it. I got to start on my rant today, and I have a great guest today. And I'm going to bring him in right after this rant, and I want him to jump in on this rant because I think he's going to have some of the same feelings as I do. ESPN and Fox are ruining college sports. My poor ACC is now doomed, and my guest is an ACC alumnus, and he knows he's doomed too. And I'm dying to get his thoughts on this. They're going to ruin everything. This is the greediest thing I've ever seen. Thank you. Well, it started with Texas and Oklahoma. We knew that the writing was on the wall there. A year goes by, and now we have USC, UCLA going to the Big Ten. I don't know what's going to happen to the ACC. You got some really good local rivalries there. But money talks, and ESPN and Fox are running this show. I'm disgusted by it. I mean, is Duke Carolina gone forever? It could be. I don't know. But on that note, I'm going to bring in my guest today, Joe Longfellow from Tallahassee, Florida, trial attorney. Joe, how are you doing today?
I'm doing good, but I feel a lot of the same sentiments you feel and you've shared, though I would not just throw it on ESPN and Fox. I mean, clearly those contracts, I mean, I think I read an article last week saying the Big Ten's income per college is going to get up to $100 million.
100 big ones.
I mean, that's
100.
That's real money.
It's insane. And I think right now the ACC is at about 35. That's,
well, you got to admit though, Bill, we've done some of it to ourselves. And,
yes.
And I'll say that from the aspect of our commissioner in the ACC, in my humble opinion, take it for what it's worth.
I totally agree. And now Notre Dame is holding the entire universe hostage. That's wonderful. And it will for some time. Joe, thank you for coming on the show. Before we get started, because I have a bunch of questions for you, tell us a little about yourself and tell us a little about your firm. I know that you guys are based up in Tallahassee. I am in Orlando. I know you're a very proud FSU alum. Tell us a little bit about yourself and the firm.
Yeah, so our firm is Andrews, Crabtree, Knox Longfellow. We've got 8 attorneys right now, 4 partners, 3 associates, and of counsel. We're looking to add another associate later on this year as the work in the litigation field has continued to increase over the last few years and continues to be on that same trajectory for the future from our perspective and our clients that we represent. I typically focus with one other partner on medical malpractice and then civil rights defense, but the civil rights defense would be specifically to representing law enforcement officers and agencies in North Florida, as well as Central Florida, or I guess Ocala would be about as low as we go on that area. But I've been doing this since 2008 is when I joined the firm, passed the bar, took the July bar, passed it, got sworn in January when I could get some family members that had put some time and my financial efforts to get me through school to be able to come down and be a part of that, what I thought was a big deal at the time. And it is still a big deal to get sworn in and all that. But we are a growing firm. We've been around since 2002. Or actually, no, 2000. We've been around, so a little over 20 years. My partners were a part of a major statewide law firm before that did insurance defense. And then before that, one of the partners clerked for a judge for several years, and 2 others worked at Holland and Knight. And so they left that realm when Holland Knight was very young, not what it is now. Yeah. And then to the defense side, insurance defense side, and got to a point where they felt like it was time to maybe create something on their own. They did so, and I got to join 8 years later, and we're continuing to build upon what they've created and moving forward. Like you said, I'm a big FSU grad. I got a family of 3. We go to games as often as often as we can. We do have season tickets, but I will admit the last several years have been hard to be committed to go to every game. So,
Well,
it's what it is. But we're excited for this year and our new coach, and excited for what the future holds for our firm.
well, I know that when the Tar Heels are on your schedule, that's an automatic W for you, and I don't want to discuss that any further. But you mentioned something interesting, because I work on some of these civil liberty, civil rights defense work in the same area as you. I believe the term is deliberate indifference in a lot of those cases. Talk to me about some of the challenges in those cases, because those aren't your typical med mal cases. And the
No.
one thing that I have picked up on those cases, which you never get in med mal, like ever, is everything at a jail is on videotape, and I mean everything. Tell us about some of the challenges handling those cases compared to maybe your standard med mal case.
Yeah, so the one thing they do have in common is, but it's a very difficult idea to get across to a jury, is we're not looking at this hindsight. This is not we know what the result is, so now we know what they should have done. It's what's at the time. That's the connection those two areas have that are good. But the difficulty we're having right now is just the general understanding of the difference between negligence and deliberate indifference with a jury.
Yep.
Because oftentimes when they hear these cases, they see them well before they ever make it to the clerk of court, whether that be the federal or the state clerk of court where they're being filed. They're in the news. They're going in there. They're seeing these videos. They're seeing parts of them. They're not seeing the entire video.
Yeah.
And they're not getting the context. And so there's a lot of bias out there that we're having to overcome, as well as the education on what is deliberate indifference versus what it's not. And that comes down to the jury instructions, as well as getting the judge on board. Now in federal court, which is where a lot of those cases are filed, it's to our benefit. The 11th Circuit's done a fairly decent job on their standard jury instructions. The state court system, at least in Florida, leaves a lot to be desired when it comes to those jury instructions. And every judge has a different opinion as to what should be allowed or not allowed. And so trying to get that education beyond my words, because the worst thing that you hear as a trial attorney is, what the lawyer says is not evidence, is not the law. Well, hold up now. If you're not going to put it in the jury instructions, how is a jury supposed to understand what deliberate indifference is? How does it rise to that level? And why is it, or why should it be okay for them to do something wrong or make a mistake? Or why is it okay to arrest somebody because you believe something might be a drug, and then it comes back and it's not a drug?
Yeah.
How do you overcome those hurdles? And that's where, it becomes very important, the whole jury selection process. And that's one of the things we're facing right now, is doing an extensive of voir dire, however you want to pronounce that wonderful term. But
depends where you're from.
Exactly. How sophisticated you are, right?
Yes. Now in my experience as well, I find, and again, I'm trying to say this politely, somebody's going to yell at me. Somebody always yells at me. I find that, and we're going to talk a lot about witness prep today. I find that witness prep with those employed by, in law enforcement, are particularly, I think they were always challenging and more difficult than standard witness preps. And then in particular, now that the view of law enforcement over especially the last 2 or 3 years, pretty obviously has become extraordinarily negative in the jury pool. What have you seen as far as your ability to work with those witnesses? Because some of them are pretty rough and pretty hard to connect with, in my experience.
I would say a lot of them are. And I don't mean anything derogatory or negative about law enforcement. I've got a family full of them, and I love them, support them. That's part of my passion behind doing this area of laws. I actually believe in what they do, and I'm very grateful that somebody is willing to put their lives literally on the line for a minimal amount of money, because they care. They really do care Uh, are there some bad actors? Yes, there's bad actors in every industry.
Sure.
I think what we're seeing, unfortunately, is we're seeing a handful of bad arrests or bad law enforcement interactions out of millions that occur in a
Yeah.
year. So we're less than 1%, way less than 1% of what we're looking at, but everybody's making that 1% seem like it's a majority of law enforcement. It's not. And so with law enforcement, what I typically see with those types of witnesses is you got some that are very rigid, very stuck. They're not personable. They don't come across as likable. It's very, this is A, this is B, this is black, this is white, no gray area. And you have to either be all A or all B. You can't be somewhere in between, a little bit of both personality wise. And so one of the things that we've been doing and have had to do is you've got to make time to meet with your witnesses.
You have to.
You cannot prep before trial. I'm sorry. You don't have time. I know everybody says they're busy. I get it. You mentioned with Brian Thompson in one of the recent podcasts, talked about time. It's the one thing we can't duplicate and get more of. And we're all busy. And guess what? If you're busy now, you're going to be just as busy right before trial. So you better figure out either get somebody to help you, retain somebody like you guys, or tell the client, tell clients you can't take any more cases. I mean, it's got to be one or the other. The give's got to be there, because that's what you're getting hired for, is to come in there and to make sure these witnesses come off as presentable as possible. And if you don't have the skill set, not everybody does. I think that's where we've got to be honest. Some people, they're naturally good with witnesses, but maybe they're bad at writing, or they're good, doing voir dire or whatever it may be. They have their strengths. We all know what they are. We should be honest and admit, hey, I'm good here. I need work here. This is where I need to get people either on my team that are that good, or I need to go search out and hire. But you've got to make them likable. And that's a difficult thing. And it's not just for law enforcement. I find it also with even the med mal, the hospital realm at times. You've got these mindsets because they're trained a certain way.
Yes, they are.
And they have to look at things a certain way. And so, for example, nurses or mid-level providers, what do? They're trained to have the answer ready by the time the question's over. Well, that's not a good tactic for that position.
No, it's not.
You don't know where attorney's going. I don't know where I'm going sometimes with my questions. It depends on your answers. I have an outline, but that may change if you give me, you say something that's not very strong, or you make it suggest or sound like there's something else. And so I can tell you, I got an example, Bill, with a client. I had a law enforcement officer I represented 2 or 3 years ago. He had a long career. And during that career, he got to see some horrible things and sustained PTSD. I mean, legitimately sustained it. So he ultimately had to get retired. He retired on disability. He was seeing a therapist still. He did not want to work with me. He didn't trust anybody.
Yeah.
He was upset. I went to his house every 2 weeks for 6 months before his deposition.
Wow.
I went to his house. I dressed in a t-shirt, shorts. I did not go in my normal, how I would meet with the client when I generally am doing that, because he needed to have a relationship with me. And so what we did was we started off just shooting the bull.
Yeah.
Getting to know each other,
Connections
that I could build with. He liked to fish. I like to fish. He liked to hunt. I like to go outside. I like to go outdoors and hunt. I like to do that kind of. So we started talking about that and just kind of working till he could finally trust me.
Yep.
Because if he doesn't, if you're not trusted, you're not going to get anywhere. It's not going to help. Now, whether you meet with them 100 times or one time, you're going to get the same result.
Yeah, we talk about a lot of this on the podcast, and when I give speeches around the country, is that the concept of witness trust, I think, is largely assumed by defense counsel. And that's often not the case. And ignoring that, or the inability to assess it appropriately, can really blow up in your face down the road. I think a lot of times, particularly when you're defending a deposition and then your witness says something absolutely insane and something that you did not anticipate. And then during the break, you're like, what the F was that? And they're like, well, and they probably should have told you that ahead of time, but either they were scared or didn't trust you. I think that's a major factor. Joe, tell us just kind of generally, it sounds like obviously time is a big factor when it comes to your witness prep philosophy. How about as far as timing of witness prep? I remember, back, you and I are, I guess, relative. I feel old. God, I feel old. I'm getting old. I know that.
Yeah.
I've aged a lot in the last year. I could tell you that much. But I know back in the old day, what my older clients say is they used to prep these witnesses the day before the dep, sometimes the same morning before the dep. When do you like to, what is your ideal timeline, and what's been effective in your experience?
I want to get it. I want to meet the people that I need to meet, know, and talk to within the first 2 weeks of getting a claim.
I agree.
Why? I've got to find out who the real players are. Just because you've, as a claim adjuster, has looked at a case and they think this person, these are the only people that matter. There may be other people out there that are either going to be brought in because the plaintiff's counsel has curiosity. They like to dig. They like, or fish is what I like to call it. Just throw out that line and see what they can get, if they can get anything to help their claim, particularly in the civil rights defense stuff, where those are just tough claims to get past summary judgment for the plaintiff's bar, no doubt about it. But usually within 2 weeks, I want to figure out, let me just talk to me. Tell me something. Tell me about yourself. Tell me if you know why you're involved, and kind of just get a general sense of what they know, as well as who they kind of are. And that's usually either going to be, and due to the last couple of years, a lot of that has had to be via Zoom or telephone, which is great in a lot of respects because it allows me to meet more people if they're not all in the same place in the same day. But at the same time, I personally believe I have a stronger ability or a better ability to bond with somebody in person than via Zoom. I can connect. There can be a connection, if that makes any sense.
No, that makes a lot of sense. I think Zoom is here to stay.
Oh, I agree.
I think it represents a huge travel time, cost savings, efficiency. But I do also think, that door swings both ways. So what we've been trying to do, I like to use Zoom. Sometimes you have to use it. I find that it's really effective for follow-up sessions, right? After you've already met in person and you need to maybe do a quick checkup here and there. I find it to be really effective. I think if you're starting and finishing with it, you may very well miss something. I do think that the level of trust is deeply impacted by whether you're in person or not. So I would say, as advice to other defense counsel out there, get in front of your witness in person. If you have to do the Zoom follow-ups, so be it. But I think that one-to-one is really important. And I also like the fact of your timeline. I do a lot of work in the transportation industry, and sometimes that timeline is within 24 hours of an accident before there's even a lawsuit. And when I can tell you, people that get sued, and you get that paperwork, right? Or you get that initial phone call from the law firm, every minute feels like an hour, and it eats at you and eats at you. And it does a lot of psychological damage. And so the more you wait to really, work with that witness, to gain their trust, and then to see how they're feeling, emotionally, I think can be really problematic. Now, you and I exchanged a couple of emails on some more specific topics related to witness prep. So use of prior deposition. This came up on our last episode, actually. Use of prior depositions. I know a lot of corporate rep depositions can come back to haunt various witnesses. How do you deal with prior testimony? Because oftentimes that's not a positive, right?
Oftentimes it's not, and as well as You know as well as I do at trial, you know, an admission's an admission.
Yeah.
I don't have to give context. I can just go and state or read from that deposition and put it in play. And you get to, as the other side, you'll get to decide what you want to counteract that, what testimony is important to you. But it doesn't often make sense, particularly when you're having to read that kind of stuff, and it can be used against you. But you've got to be familiar with it. I always ask, hey, what's going on? And a lot of our clients are clients that we do a majority of their work for that hospital or for that agency. And so we know what's out there. We already have it. We were involved with someone in the firm was involved, whether it be a partner or whether it be an associate in that case. And so I always like to read them. And I'm not going to read them just once. I'm not going to read the summary. I might start off reading the summary just to kind of get an idea so I understand generally. Yeah. And then I can figure out how much time I need to spend or where I need to go and look at testimony in more detail or more depth than I would in other places. I mean, obviously the beginning of a depo, the first 5 pages are a waste. It's an talking, trying to build a relationship of trust with a witness that's usually adverse.
Yes.
And you're not going to do it. You're not going to, I don't believe that I'm going to trick you into thinking, hey, I'm a good guy, just like you, even though we're on opposite sides. Tell me the real story that you're coming back. That doesn't happen, but you've got to go through them, and you've really got to know what, for example, the corporate reps are going to say. But it's not just the corporate reps that I like to go back and use old testimony. I like to pull testimony from the attorneys. And in my world, there's a handful in both areas, maybe a little bit more than a handful of attorneys that I run into all the time. I know how they're going to ask questions, but it doesn't matter if I tell you as the witness, hey, I'm going to ask the question kind of like how he's going to ask it, and this, or she's going to ask it, and it's going to be like this. I find it more effective when you can pull out a transcript and you're going, okay, so this is how his order is or her order is in asking questions. They ask this question, here it is. How would you answer the question? Making it more detailed, specific to your case, tailoring it. Now, I don't usually do anything like that until probably my 3rd meeting with a witness.
Good idea.
By then, I've had 2 opportunities to build a relationship.
Yeah.
Either in person or via Zoom. And usually, like you suggested, or you do, my second one usually is via Zoom. I've gone down once, I'm coming back. I've called you before the first visit. I spoke to you probably for about 30 to 45 minutes, explaining the process, how long it's going to take, what you realistically should expect as a party defendant to the case or as a witness to the case. And usually if you're a witness, that's pretty important. I'll let you know, hey, you're fairly important in this case. Your care is at issue. You're not being sued directly, but I'm going to need your help the whole way through, and this is to help your name. But the third one, I'm sitting down with them. We're going to go and we're going to start asking questions. And I like to do more than 3. I know that some people say that's an overkill because you said, the old days where people would meet the day before the day of. People are still doing that. I'm seeing young attorneys.
It's crazy. It's crazy.
And I'm thinking, hold up a second now. And what we do, 98, 99% of every case settles. I try about 3 to 4 cases a year, which is quite a heavy load for a defense attorney in Florida. And so if my case is going to settle, what am I being hired to do? Minimize the risk, minimize the loss. How am I going to do that? It's the discovery phase. It's got to be. My witness has to do a good job like they would do in trial. And I've got to have them ready and thinking like they would be thinking at trial. Plus, let's be honest, when you get to trial, the month before, time is definitely not your friend. You've got to,
it's not.
You got to put cases on hold.
Yep.
You got to focus on this. Yeah. And we have a bad habit, and we've been permitted to do this as trial attorneys, to start scheduling the crud out of things at the last minute and following all the emotions and stuff. And, it just makes everybody's job a little bit more difficult. It tightens the belt on the time frame. So you've got to not have to, you can't be focusing all on witness prep. That's at the end. That's where you fine tune things.
You need to be way ahead of the game at that point. When you instruct a witness, now I'm going to throw out one of my pet peeves. It's highly controversial, but I will argue to the death because I think I have science to prove that I'm right on this, but I want your opinion on this. I wholeheartedly disagree that a witness should be instructed to try to win the case at deposition, that they should be instructed to argue, with plaintiff's counsel to get points across. And kind of like the same thing is like, yeah, attorneys are still out there prepping witnesses the day before. That still happens. Well, I've seen some disastrous depositions because the witness was instructed like, hey, you're a home run hitter. You have a chance to win this case at dep, and don't take any shit off of this plaintiff attorney. You stick it right to them. What are your thoughts? Because I don't think that I've only seen negative outcomes with that philosophy.
I will admit, when I was younger, I was a younger attorney. I was a lot more aggressive. Some would say it hasn't changed much. I can be a little competitive, to say the least. I guess would be nice.
I could see that.
But I agree with you wholeheartedly on that. I don't see where you're going to win points here. It's kind of like an expert witness.
Yeah.
My goal is to put you in a corner. I want your opinions locked, sealed, locked, and signed. I want to know what they are, and I may try to get you in some positions where you might agree with some things. But I know if you're an expert witness, you're not going to go, you know what, Mr. Longfellow, that guy you hired, he's exactly right. I was wrong. They paid me. That's not going to happen. And it's the same thing with your major witnesses. And all cases happen. You have witnesses that are going to be vitally important. If they fail,
case is over.
Yeah. It's a matter of how many zeros are behind the one.
Yeah.
That the check's going to be writing. And have you increased the value of the claim because of the risk, or have you minimized it? And so I think the important point is, I want you as the witness come off likable. Because at the end of the day, whether we like it or not, whether we want to agree with it, whether it's fair or not, our judicial system comes down to, do I like you or do I not? Because if I don't like you as a juror, you have no credibility.
Yeah.
And those witnesses that are important to your case, your theme, what you're arguing, why they should go with you, starts to crack that whole foundation.
Yeah.
And there's nothing, I'm not saying, somebody like you guys couldn't come in and help rehab it, but there's only so much you can do when the foundation is cracked all over.
Yeah.
And you incorporate the help when you should have, because either it's a tough case, it's a tough witnesses, or it's not your forte.
No, that's a very good point. Joe, how do you handle and this is a very uncomfortable question, and an uncomfortable situation for main defense counsel. How do you handle the circumstance when you have important fact witnesses that do not agree with each other? Maybe doctors, nurses, you know what I'm talking about, how this goes.
No, exactly. And that's one of the most difficult scenarios that we often run into is you got contradicting witnesses. And that's the plaintiff's dream, right? Is to get the defense to start fighting amongst each other and then just sit back and say, hey, I don't care who you hit. But you can clearly see there's a problem here. So somebody's responsible and everything. So what I usually like to do is, if there's other attorneys involved, co-counsel, co-defendants in there, I like to reach out to them and say, hey, look, what's your read on the case? Where are you at? What are you seeing? What are you thinking? And kind of bounce some ideas off of them and just get a general sense of where they're at and where their witnesses are. Now, when it's just me and I've got a hospital and I've got some witnesses that have different testimony or opinions, I like to go through the records, for example, in that scenario, in detail with them and figure out how much is really their recollection, their hope, their aspiration, or CYA, because it all comes back to this trust point that we mentioned earlier. And I'm a big proponent of building relationships of trust with everybody you're dealing with, but particularly witnesses, because sometimes witnesses, they're scared. There's no doubt. Even if they're not the center of it, they're afraid. They've never been through this process. It's very foreign. I'll be honest, I would want to be a witness. You're telling me I don't get to ask questions. I don't get to push back. but they get to attack me.
Yeah.
Oh yeah, that's a situation I want
That's
to be
fun.
in. Yeah, exactly.
Where do I
Sign me up.
sign up?
So you've got to sit back and you got to hear what they both have to, all they have to say. And then you've got to come back to, I like to come back to my partners or my other associates and say, we need to talk now. This is what's going on. How do we overcome this? Who's right? Who's wrong? Who maybe has it a little bit right, a little bit wrong? And generally speaking, usually everybody's a little bit off, and they kind of need to understand the whole time frame and understand what's going on. And so when you do that, it allows for like a second meeting or a third meeting where you come in there and you say, I know you're testifying to this, but let's talk about this. Is this logical? Does this make sense?
Yeah.
Because that's what's going to happen anyways in a deposition, right? The other side's going to push to see how firm you are on your position.
Mm-hmm.
And I don't think it's quote unquote coaching the witness or telling the witness what to say. Because I don't believe we can do that, but I think we can give them tools and help them understand and see things where maybe they need to reconsider where their position is. Not that they're completely off, but is there something where maybe they're my kids would say disremembering, which I know is not a word, but they're just not remembering it correctly.
Yeah, and I think it's particularly in healthcare litigation, particularly whether it be nurse doctor or doctor or nurse. I always try to tell these, you're there to testify on your experience, your conduct, your decision making. You're nurse A. The fact that nurse B did something, whatever it was, were you there? Were you in that nurse's head? Okay. The answer is no to both of those. You shouldn't really be answering that. You could say, I can't speak for nurse B. You'd have to go ask him or her, which I find a lot of healthcare professionals struggle with. They want to be right. But the worst, nurses are bad enough with that. You get two competing physicians on opinions about something. Man, talk about hard-headedness and sometimes inflexibility to just defer, because I find that physicians, particularly those involved in high-level surgeries and stuff like that, surgeons, they don't like to defer. They like to have an opinion, even if they are a surgeon and they're maybe have an opinion on a cardiologist or a nephrologist. Do you see a lot of that?
You do, and in your initial meetings, you got to remind everybody: look, everybody has a specialty. The way MedMal works is you opine on your specialty. Now, the other problem we have in medicine that is so different and unique from other industries and other business or jobs that people have is the gray area. I don't know any profession that has a larger gray area and a smaller black and white area than medicine. There are so many symptoms, and I talk about this with all my witnesses. Let's talk about certain symptoms. Like, okay, I'm going to call these symptoms non-specific. Are you comfortable with that, doctor? Yes, I am. Okay, would this be a non-specific? This, and this. Okay. So what does that mean then? What's your differentials going to be on that diagnosis with that? Well, it could be A, B, C, D, E, F, G. That's my whole point, doctor. Could it be something else under these circumstances? Is it based on the presentation to you, what you're seeing when you're there, that may not be in the medical records? Because not everything has to be documented. And I don't prescribe to the belief that if it's not documented, it didn't happen. That's bullcrap. There's so much you do. There's so much I do that doesn't get documented down either in a time record or in a report and stuff. Hey, I'm doing this, and this. Well, it's not really germane or necessary that they know I'm doing this. They should assume and expect me to do that. And also going on practices and procedures. What do you routinely do? And a lot of nurses, particularly and doctors, well, I do this normally, this and there, but I don't know if I did it. Okay, well, if you didn't do this, wouldn't you document that? Because that'd be out of the ordinary. Well, yeah. Okay, then why wouldn't you be confident you did this? Well, I just didn't write it down. Okay, well, I get that, but you do every day.
Yeah, boy, those healthcare cases are tough. Healthcare witnesses are tough.
Well,
it's and I think the toughness is because you're typically, this is not commercial litigation where a company loses money in a contract dispute. It could be a a bad baby case, a birth injury, catastrophic stroke, or death. I mean, the amount of emotion going into these witnesses is sky high, right?
It is, and fighting with each other is not going to make anything better. The stay in your lane kind of mantra or philosophy going on now is one that we often have to imply. It's because, look, it's not going to do any good arguing with this and that. You did this. Can we justify it? They did this. They're saying they can justify. There's an expert that says that. So you need to stay away. And depositions are based on your personal knowledge, particularly when you're a fact witness or a party witness. It's not based on, you're not an expert, so you don't need to come in here and get these facts and essentially give a speculative opinion based on if X, Y, and Z were true, then it would lead this, or more likely than not stuff. But I think when you have those emotions like that, everybody's upset because think about it from a physician side. You're questioning me doing my job, my competence, my knowledge, and my ability. And for doctors, particularly surgeons, name is everything. Reputation matters more than anything. And if that's very important, then we got to make sure that we protect. And I think if you go from it or go at it with that perspective, saying, hey, look, I'm trying to protect your name, your reputation. I don't believe you did anything wrong. I've got the support for it, but this is where I need you to be. So we need to focus on this, not over here. Don't worry about that right now. Let's focus on this, and everything will fall out the way it does. But once again, it goes back to that trust aspect of doing that, and also helping them see the big picture at the end of the day. Doctors need to see it. They also need to understand and feel that you're not wasting their time. They're kind of like, and we spoke about this a lot, the bill by hour. I mean, it makes or breaks us, right?
Yeah.
It is what it is. Whether you like it or not, it exists for now, and that's how we operate. So you've got to maximize their time and not waste it, because that could be a patient or a surgery they could be doing, as well as for you. You could be focusing on something else that you need to focus on.
It's got to be important. Joe, thank you so much for coming on the show. I love your LinkedIn. You post a lot on LinkedIn. I really like your posts. So I encourage our audience to everybody follow Joe Longfellow on LinkedIn. He always puts some interesting thoughts almost every day, it seems like. Great job. Joe, last question. We're going to fast forward to 2025. This is a multiple choice question. FSU will be in the A, SEC, B, Big Ten, C, the ACC, D, none of the above.
A.
Wow.
Inevitable. It's going to be two conferences, Bill. It's college football with NIL and everything that's changed over in the playoffs. It's, in my opinion, we've ruined college football. It is now a minor league system, is what it's turning into. And what I loved about college was you were playing for the opportunity to get the money. It was a great motivator. And I do believe players and individuals need to have rights, and they need to be protected. But at what cost? I mean, where's the balance? And I think we've ruined the balance. There's no balancing act there right now, and it's all become about money. And money's important. Don't get me wrong. But I see the ACC as it's the next one with the Grim Reaper at the door now, and it has been coming towards us for a while, unfortunately.
I am not looking forward to that, particularly for college. I'm a basketball junkie. I love football, but man, I'm a basketball junkie, and to not have Duke Carolina, I don't know. This is going to be, but I think basketball. I think the basketball folks are watching very closely to see what the football people do, and they're going to make their own plan.
But the thing you got going for you up at Duke and North Carolina up there, those UNC, those schools there, the performance with football and the increase there, I think their value has increased over time. And I don't think they get left. I don't ultimately think they get left in the ACC. I don't know where they go ultimately, but I think they stay together. I think they're a package deal. And I think they're going to be the Big Ten, or it's going to be the SEC. One of those two is going to take them. It's just a matter of who and when.
Yeah, because I really want to go to Lincoln, Nebraska in November for a football game. Anyway, Joe, thanks so much for coming on the show. Be in
Yeah.
touch. Always here to help you, witness prep, focus groups, mock trials, whatever. To our audience, thank you very much for participating. We love doing this podcast for you. Litigation Psychology Podcast. This is Dr. Bill Kanaski signing off. See you.